Jack Smith threatens Judge Cannon, very unhappy with her because she's not issuing a ruling that he wants. He wants Trump to be, I guess, executed immediately, but that's not going to happen. So the next best thing is he wants the jury instructions to be rigged in his favor. And of course, Trump's team has said, no, we don't want that to happen. And Judge Cannon has released some jury instructions that Jack Smith is very upset about. And so he filed this motion raging at her, saying, if you don't find in our favor, guess what, Judge? We're appealing this, and we're going to appeal it very hard, and you're going to feel very bad about it when we do. So we're going to read through some of the highlights from Jack's raging motion and see what the left is so excited about. They're doing cartwheels over this motion. Finally, Jack Smith is coming to play. He's showing up now. Judge Cannon's on her heels, and all the things you hear from Brzezinski and so on. You're going to hear it from Tristan, who we're going to hear from in a little bit, and from the Spice Girls, from the TDS Spice Girls. So we'll hear from them, but let's see what Jack Smith is so hot and bothered over. Here is what the filing says. It's from Jack. It is West Palm Beach Division, Southern District of Florida. Courtroom is Judge Cannon presiding. This is deranged thug Jack Smith's response to the jury instructions and the verdict forms on these counts. And we've already read through Judge Cannon's interpretation of the law, and it's basically saying, as we remember here, because we've read through the opinion from Amy Berman Jackson in the DC Circuit and the Clinton sock drawer case with his literal recordings. Okay, Bill Clinton, as a recap on that case, Bill Clinton had some historian, archivist, writing, author person come sit in with him and audio record a bunch of files for a book he was writing. Well, problem is, some of those audio recordings captured the president doing the presidential duties, okay, actually doing the job of the presidency. This court issued an order directing the parties to file proposed jury instructions. And you had in here, the judge wrote, engage two competing scenarios and give me your thoughts on it. And both scenarios rest on a flawed legal premise, namely that the Presidential Records Act, and in particular the distinction between personal and presidential records, determines whether a former president, Trump, is entitled or authorized under the Espionage Act, which again, this is an act of Congress, okay? So I always make this point that this is an Espionage Act, which is Congress trying to override the presidential authority to have his own documents, which is granted to him under Article 2 of the Constitution. So unless 18 U.S. Code 793 is a constitutional amendment, it is subordinate to the president's Article 2 powers. Sorry, Congress. So Jack is going to continue to rely on this. He says, and there are other contrary rules from other executive orders, and so the legal premise is wrong. And a jury instruction from you, Cannon, would distort this trial. The PRA's distinction between personal and presidential has no bearing on whether a former president possession of documents that contains national defense information is authorized under the Espionage Act. And Jack says the PRA should play no role in the jury instructions. I don't think so. Sorry, Jack. Indeed, based on the current record, the PRA should not play any role at trial at all because the PRA is devastating to their case because Bill Clinton used it to keep his records, and Trump could easily rely on that as precedent and say no one was prosecuted before because guess what? No one was. And no one has been, right? Joe Biden had classified documents, no big deal. Now, moreover, it is vitally important that the court promptly decide, okay, here comes Jack Smith's threat, whether the unstated legal premise underlying the recent order does, in the court's view, whether you believe it is a correct formulation of the law, right? This is Jack saying, you better decide this real fast or else. If the court wrongfully concludes that it does, and that it intends to include the Presidential Records Act in the jury instructions regarding what is authorized, it must inform the parties of that decision well in advance of trial. Why? Because Jack Smith wants to go and appeal this thing. We must be able to consider the appellate review. We're going to take this up to the circuit court. If this court, says Jack, concludes, as you posited in your order, if you say, and watch what Jack does here, if you say that under the Espionage Act that a former president is authorized to possess any document that the jury determines qualifies as a personal record under the PRA, that would wrongly present the jury a factual determination that should have no legal consequence under the elements of 793, right? So Jack is trying to charge him like he's a regular civilian citizen defendant. He's not. He's the president. So he gets the Presidential Records Act. Jack is saying, well, that can't conflict with the Espionage Act. Yes, it can. And also Article 2 powers, which the PRA is basically building on. Now, likewise, if the court concludes, as posited in scenario B, and watch what Jack does here. It's so ridiculous. Like, Judge Cannon never said any of what Jack Smith is going to say. This was not in her order that we read. But he says, if this court concludes, like you did, Cannon, that Donald Trump has carte blanche to remove any document from the White House at the end of his presidency, that any document so removed must be treated as a personal record under the PRA as an unreviewable matter of law, and that also as a matter of law, that a former president is forever authorized to possess such a document, regardless of how highly classified it may be and how it may be stored, that would constitute a clearly erroneous jury jury instruction that would entail a high probability of failure. Right now, this is not how Cannon phrased it, right? This is snark. You may not be able to sense it, but he's being snarky here. Okay, Cannon, if you can say Trump can do whatever he wants all the time with the documents all the time, no matter what, and act like Big Fanny with no consequences doing whatever he wants all the time, well, then you're going to be clearly erroneous. And to be honest with you, I think that he's clearly erroneous on this. So who is authorized then? Who is more authorized to tell the president no? Jack, who is that? You? Some prosecutor somewhere who gets to override the chief executive of the whole country? Huh, that's strange. Now, as in any case, Jack continues, the court may defer ruling on certain aspects of jury instructions when the jury instructions might turn on evidence that's presented at trial. For example, whether the jury should be instructed on all these things. But the question of whether the PRA has an impact on the element of unauthorized possession under Section 93A, right? So the law has different rules. Someone has to have unauthorized possession. Trump is saying it wasn't unauthorized at all. It was perfectly authorized as a personal record following the Bill Clinton precedent. Does not turn on any evidentiary issue, and it cannot be deferred. It is purely a question of law that must be decided promptly. If the court were to defer a decision on that fundamental legal question, it would inject substantial delay into this trial. It would prevent the government from seeking review before jeopardy attaches, and we need to know. So as instructed by the court, the government provides a clear and well-supported jury instruction for these elements. The proposed instruction correctly instructs the jury that the element of unauthorized possession just depends on the statute. That's it. On executive orders here and on executive orders implementing regulation, and it makes no mention of any designations under the PRA. Okay, so again, they're trying to cordon Trump off. They're just trying to charge him like he's a regular citizen. Says, oh, we've already got a bunch of rules on this, and the Presidential Records Act doesn't apply. You can't use that as an escape valve. Now, as required by the court's order, the government also provides jury instructions that incorporate the inaccurate legal premises that are reflected in the other scenarios. And furthermore, even though resolution of the threshold legal issue is purely a matter of law, so you should decide that now, right? It doesn't go to the jury. The court should be aware at the outset that Trump's entire effort to rely on the Presidential Records Act is not based on any facts, which is weird because Jack Smith said that the decision to move the boxes was done on January 20th at the tail end of the Trump presidency, which means those were presidential acts. So Jack, in his indictment, right, even admits that these were done during the boxes were taken during the presidency. Jack says it is a post hoc justification and after the fact justification that was concocted more than a year after he left the White House. And his invocation in this court of the PRA is not grounded in any decision that he actually made during his presidency to designate as personal any of the records charged in the indictment. So Jack, again, is missing the whole point. The Clinton precedent says, who does he need to designate it to? He needs to fill out a form? And what happens if he doesn't fill out the form? Are you nuts? The fact that he literally took the documents, this is in Amy Berman Jackson's opinion, the fact that Bill Clinton didn't turn in the presidential records, okay, just like turning in your homework. These are my records, archive these, archivist. The fact that Clinton didn't do that, guess what? That means they're not presidential records. And the archivist, according to Berman Jackson, doesn't have the authority to challenge the presidential discretion. So accordingly, they say before turning to the jury instructions, we are providing factual context about Trump and how he's trying to inject the Presidential Records Act into these proceedings. Now, importantly, Trump has never represented to this court that he in fact designated the documents as personal. Again, that is not his requirement to do that. Clinton just took them. He doesn't have to fill out a form. If he did, then the person who is in charge of the form is the person who has the authority. Just to be crystal clear about that. If Trump fills out a form, I'm making this declared and somebody, oh, sorry, that's too classified. You can't have that. That person has the power, not Trump. And that's not how it works. He made no such claim in his motion to dismiss, nor was he required to. He doesn't have to tell you what he's doing in his reply or at the hearing, despite every opportunity and every incentive to do so. No, but he brought it up now. Now, as discussed below, the reason is simple. He never did so. Instead, he has attempted to fashion out of whole cloth a legal presumption that would operate untethered to any facts. So without regard to his actual decision or his actual intent, the unambiguous definition of what constitutes personal records or the plainly non-personal content of the documents, there is no basis in law or fact for that legal presumption, and therefore the court should reject Trump's effort to invent one to bring and inject the PRA into this case. Says there is no colorable argument that anything is a personal record. To the contrary, they're classified, making them presidential records. It's not straightforward, okay, because Judge Berman Jackson said that Bill Clinton was the sole person who got to decide whether they're presidential or not. You don't get to challenge that because you're not the president. So Jack's trying to go into all this indicia to sort of make his claim. And then they're saying Trump has not argued argued otherwise. Indeed, it would be pure fiction to suggest that highly classified documents created by the so-called intelligence community were purely private and that they do not relate or have an effect upon carrying out. It's the same thing. So they'll rely on that. But Trump has sought to inject the PRA and saying that he would be impervious to judicial review, which is exactly what they talk about in Judicial Watch. Now, the argument that they'll make against Judicial Watch is that they're a third-party entity, right? And that this was NARA. But if you read the decision, and I reviewed it again today before the show, you see some very, very serious doubts there from Berman Jackson, the judge, about whether NARA has the authority to even go after and challenge anything that the president has already decided is not presidential. So during its exhaustive investigation, says Jack, the government interviewed Trump's own PRA representatives and other numerous high-ranking officials from the White House. Not a single one had heard Trump say that he was designating records as personal. And he doesn't need to. He doesn't have to give an order, right? He's the president. He just does it. At the time he caused the transfer of the boxes, he didn't tell them that he believed the removal of the records to be designated as personal. To the contrary, every witness who was asked this question had never heard such a thing. This is bizarre. So, Jack, it sounds like this is a factual issue that should be decided at trial, isn't it? You can present your evidence and Trump can present his. So why are you trying to foreclose on this possibility? This is all fact stuff, okay? Some of the clearest evidence that Trump did not designate the documents come from his own statements. For example, during a year of correspondence, they didn't bring it up. They didn't even mention it. All the correspondence back and forth and his off-the-record interview with writers, Trump never suggested that they were personal records or anything. And later, after Trump gave some boxes back, he says, you know what? These are presidential records. You can have these back. Trump released a public statement in response saying they didn't find anything. Jack Smith just got done lecturing us about how this is a purely legal issue and Judge Cannon better rule on it right now. And then goes through all these facts. Like, okay, Jack, if you think that the Presidential Records Act is not a part of this, well, then make your case. But it sounds like the Presidential Records Act is actually dispositive. Like, it's a big deal. That's why you were asking everybody about it, isn't it? Why are you asking everybody about Presidential Records Act, personal records? Because you know it's a big deal. And here are some statements from Judicial Watch, apparently, that Trump here on February, the Washington Post article, the president of Judicial Watch, right here, posted the following two statements on X. Says, the left-wing media is being dishonest about the Trump records issue. A president has discretion on what docs to retain as presidential records while in office. So the law allows Trump to tear up documents, shred them, take documents when he left the White House, do whatever he wants. Yeah, he's right. Fun story. Judicial Watch sued over Bill Clinton hiding the records in his sock drawer. Courts told us to pound sand. He's right. I read the opinion. It's Judicial Watch versus NARA, Amy Berman Jackson, D.C. Circuit Court. Because presidents essentially can do whatever they want with their records. They're theirs. How dare we tell a president who got elected by the American people that, sorry, Deborah is in charge of their records? Remember this when you hear anti-Trump media caterwauling about him tearing up documents. But Jay Bratt wrote this. It is just a stupid opinion. He says, for the reasons here, the court should reject the legal premise that the PRA has any part of this. As such, it should deny Trump's motion and adopt our jury instructions. If you don't, let us know right now, says Jay Bratt, long before a jeopardy attaches, because we are about to seek appellate review. Signed by Jay Bratt, David Harbach, out of Florida. You know, they want to isolate Trump from the other protections of the law. They admit that the Presidential Records Act is pretty important, and it does exonerate him. You know why? Because they asked everybody about it. Now, the fact that everybody about it didn't know anything about it doesn't mean that Trump wasn't using that power, as we saw, right? Tom Fitton and others have set the precedent by suing Bill Clinton, and the judge established then that no one can challenge the presidential authority. If so, how do you do it? What are the limits on that? What's the standard of review? What's the statute of limitations? How much discretion do you afford to the president? What's the balancing test? You know, is it ultra top secret or only super top? You know, what's the standard? No guidance to that at all, because it's the president's record. And the standard is obvious when it's Bill Clinton, but not obvious when it's Trump, apparently. So let's see what some people are saying about these Trump prosecutions. This guy's called Tristan. He looks like a Tristan, sounds like a Tristan, and he is, of course, on MSNBC. And we're not inside Jen Psaki today. We're inside Michael Steele. He's filling in.
Is going to take? Is there something that, you know, we should be looking at being dragged out, or is this something that could get turned around pretty quickly?
Yeah, Donald Trump's biggest weapon when he's trying to evade justice, and I talk about this a ton in my book, is delay. Ultimately, a lot of the things that he does, what are all these distractions, the clown car full of lawyers? What is he trying to do here? He's just trying to throw sand into the gears of justice, try to actually stop it from happening.
It's called due process of law, Tristan. Trump has a right to, review evidence, to have evidentiary hearings, to file motions to dismiss, to take things up to the Court of Appeals. He's not delaying anything. Their side delayed all four of these by waiting until 2023 to drop all the charges simultaneously, right? Trump asking for slight delays. These cases shouldn't go for years, right? This is a 2016 case, by the way. The New York case is 2016 is when it all originally started. And the Florida classified documents case, that apparently the crime started on January 20th, 2021. So why did they wait until August of 2023, essentially, to start dropping charges? Because they are using it as election interference, Tristan. You know that.
And then he hopes that this is going to cause other things to break his way. And in the context of the election, he's hoping that it's going to allow him somehow to win and then be able to wave some sort of magic kingly wand and, monarch or dictator his way out of all of this.
It's not actually a monarchy or a dictatorship, okay? That's called the power of the presidency. And if the people elect Donald Trump, you know what that is? It's the people's veto of the prosecution. They just say, yeah, this is not, obviously he's not insurrectionist terrorists, whatever you guys psychos say on MSNBC. But what happens is Trump goes in, he takes the executive office again, and now he's in charge of the DOJ, and he should, with a stroke of a pen, just get rid of it all and reopen investigations into them. How about that, right? If you're going to use power as a cudgel against your political enemies, well, then we'll do it too. And this is due process. It is not delay, delay, delay. And Trump would exercise the power of the presidency to reverse this. So that is Tristan. And I told you, looks and sounds like a Tristan. But we also have out there TDS Spice Girls. Now, we're very familiar with them. We know Clavicle Girl and Alyssah Farah. I think she's on The View still. They make up two of the three, but they're out there, okay? Sitting in front of this principles first. Clavicle Girl, in my opinion, is a bona fide liar. She met with Liz Cheney 4 times, and then on the 4th time came up with the clavicle story that apparently she made up out of thin air. No one ever told her about it, according to the people who she said told her about it. They said, what? Clavicle? The hell is she talking about?
What I want to tell you as somebody who knew him very well and spent a lot of time with him is the worst things you have heard are only scratching the surface.
Oh, no.
This is an unprecedented moment that we are in.
That's crazy because we've heard he's Hitler, okay? So that's only the surface. It's like, oh my gosh, he's Hitler and that's just the beginning? What else is there?
There has never been, now granted, we're some of the more vocal former Trump staffers, but he has been denounced by all of his most senior staff, something we've never seen in modern American history before. Multiple White House chiefs of staff, multiple secretaries of defense, his former national security advisor, his former White House communications director. People who saw him in the most important decision-making environments have spoken to the fact that he is unfit and that he poses a threat to democracy, and people need to wake up to that.
Oh, well, we're woken up. We can't wait to get in those polls and vote hard for him, okay? Because nobody believes anything you guys say, because you're liars. Clavicle Girl being the prime example. So the TDS Spice Girls are going to be out and about. We're going to see a lot more of them, no doubt. And we're going to be here continuing to cover this, my friends. We're going to see what Trump says, what Judge Cannon says, and how all this unfolds. We're waiting for jury instructions to come out in the classified documents case. Jack very upset about it. Tristan unhappy as well. Thank you for subscribing and joining us as we do. Appreciate you hitting that like button, inviting someone else to come over here that you know or love. Come join us so they can see what's going on behind the scenes in all of these cases. We got great links down in the description below. Sovereignty Saturdays are free. They're over at watcherlodge.com. We'd love to have you come and join us, talk about some other stuff about sovereignty and self-development. And we have watchingthewatchers.locals.com, our members only community, where we talk about other stuff that we can't get into here. And we look forward to seeing you over there and back here on the next one.